Our next panel, and we're going to pick up some of our time we lost earlier, our next panel is on land use. The moderator is Lee Dobbins. Lee is a graduate from Duke University, undergraduate, and has his JD from University of Florida. Lee, we want to bring the rest of your panel up with you. There they are. Gentlemen. Lee's practice is in land use, zoning, commercial real estate transactions, and has been working closely with us on a number of our utility transactions. I don't think there's probably a large development in South St. Lucie County or most of St. Lucie County that Lee's fingerprints haven't been on. And as we have had quite a bit of change over the past year in our land use rules in the state of Florida, we thought it'd be a timely topic to discuss. Lee?
Great. Thank you for that introduction, Michael. We've got a couple of excellent panelists with me this morning. To my right is Mike Busha, who's the Executive Director of the Treasure Coast Regional Planning Council. He's got almost 30 years of experience with the Treasure Coast Regional Planning Council and has been Executive Director for 16 years. On my left, I have Jim Sellon with VHB Miller Sellon, and he's former Planning Director of Orange County and has more than 20 years of planning, design, and environmental experience. And we're going to cover a few different topics this morning that are timely in the area of land use that can affect agricultural operators in particular. Mike's going to talk to us about sector plans and rural land stewardship areas. There have been some changes that came out of the Florida legislature recently on those. And Jim's going to talk to us about water supply planning for Central Florida. So Mike, if you'd like to kick us off, why don't you go first?
Sure. Can everybody hear me okay? Thanks for having me up. I guess this is these two topics, the sector plan and the rural land stewardship area plan, is not two new ways, but two sort of modified ways in which government is going to help agriculture again. So I'll do my best to sort of walk you through this. I'll be available afterwards if you'd like. I can answer some questions. What I can tell you for about 40 years that Florida has been involved in some sort of long-range planning, mainly through the development of regional impact process. And say what you will about the DRI process. I heard this legislative session, it was the end of the DRI process, but I guess the folks out there who sort of know what they can expect from the DRI process liked it enough to keep it around, at least this year. But there was something else going on in the legislature and with the administration this year. There was a sort of a mission and a challenge related to large landowners in this state. And the challenge really was, how does Florida get beyond the DRI process, which I don't believe has been very effective at large, long-range regional planning. I mean, it has its pluses, it has its minuses, but it never really got at the 40,000 acre, the 100,000 acre notion, people who had a notion that they wanted to do that kind of planning. And so the challenge was really, how does Florida encourage its largest landowners? How do they encourage its largest landowners who are moving from sort of a hold and harvest position to one of development, or even if it's way out into the future, at least we're thinking about entitling those lands so that when the time came, they were in a great position to do that. And it also, the challenge was, how do we get them to do large, really authentic, long-range planning? And Florida found its biggest advocate really when the governor hired Billy Bezette as Secretary of the Department of Community Affairs. He has a long history of experience with DRIs, but even more recent experience with a sector plan up in the West Bay area, up in Bay County, a 40,000 acre, I guess it was St. Joe's Holdings, some of them anyways. And he came out of that process with the notion that, look, because sector planning was only optional for 5 different locations in Florida, he liked it enough to actually go through the law related to sector planning, take out the optional part, and now it's available to all large landowners in Florida, really in almost any location. So, and I know he personally went through the sector plan law, and a lot of the changes I'll talk to you about, just the three big ones, were a result of his review. The sector plan has two pieces to it. When you're thinking about this as large landowners, it has two pieces. The first is simply a long-range, sort of general master plan, laying out what it is you think you might want to do on your holdings over the next 50, 100 years, because there really is no limit in terms of how long, in terms of long-term planning you can think about. And that was one of the good things, I think, about sector planning. The second piece to it is when, in fact, you're actually ready to do construction, there are things called special area plans. And one of our panelists is very familiar, Mr. Selling. One of the optional sector plans that was done very successfully by Jim's firm was the Horizons West plan in Orlando. So there is some track record, there is some experience with this kind of planning for large landowners. But so it's no longer a pilot program. Everybody's available to do it. There's a minimum size was increased this year from 5,000 acres it used to be. We were looking for 5,000 acre parcels. Now you have to have 15,000 acres under ownership. One of the big things that happened, it's very difficult to know 100 years from now, 50 years from now, and demonstrate that there is some need for more housing, more shopping, whatever it is you might want to do. The demonstration of need requirement it is no longer a requirement. So you are free as a large landowner to go ahead and think out 50 years or 100 years and make some decisions about entitlement of those properties for the future. The other thing that came out of this is that once this long-term master plan is adopted, there was always a distinct possibility that another regulatory agency, maybe the South Florida or Water Management District of your choice, or transportation planning agencies, the metropolitan planning organizations and things like that, which directly influence how local government thinks and feels about roadway concurrency and capacity. Once your long-range master plan is approved, the regional water supply plans that the water management districts all have to do for planning, they automatically have to consider that long-range plan. Okay, it's baked into their process. They have to bake it in themselves. So you don't have to go through a lot of that. You're not guaranteed a permit, but in fact, at least they are considering you as part of the picture as they move forward each year with their updates to the regional water supply plans. The MPOs also have to amend their long-range regional transportation plan. It's one of the three big things MPOs do. They call out for local governments what their priorities are. Once your long-range plan is done and adopted, they have to go ahead and amend their plan. At no cost to you, they have to amend their plan to reflect the capacity that would be needed for one of these sector plans. Now, there still is sort of adult supervision, government oversight on all of this. And I'll get to the other thing, the Rural Land Stewardship Program in a minute. But the way these long-range master plans, the first big piece, and then these special area plans that have to be done as you're ready to develop, you have to sort of give some more detail, is that you still have to go through the comprehensive plan amendment process, Chapter 163. And that's how you would adopt your long-range master plan. Okay, so there's still that. You're really negotiating with the local government throughout the whole process. The Department of Community Affairs, you can ask them to get involved. You don't have to. So you're really working with the local government. But when you decide to submit these special area plans, when you're actually ready to build something, then you have to go through, and when the local government issues what's called a development order, those of you who are familiar with the DRI know there is a development order attached to a development of regional impact. So this is a little bit of a hybrid here, that the Department of Community Affairs, or I call them that, I know it's not the right name, but
Don't exist
the
anymore.
State Land Planning Agency will still look at and review that development order consistent with the DRI statutes. In other words, they will take 45 days to have a look at these special area plans, and they in fact can go ahead and appeal. One of the things that changes in the law, if they don't like it, one of the things that changes in the law, if there is already another adjacent party or affected party that has decided that they don't like very much what's in these special area plans, the DCA has to step out. There's no fair piling on the landowner. DCA has to step out if, in fact, there's another party, an affected party, that has filed an appeal. So DCA has to step out, or the State Land Planning Agency has to step out. The other tool that's out there, it's been out there for a while, it hasn't been used that much. It was used in Collier County. In fact, that was the case study. That's what the statute was built around, the Collier County Rural Land Stewardship Area Program. Very effective, if in fact you can find your way through some of the issues with it. Look, the Regional Land Stewardship Program, 10,000 acres and up, you're eligible. I'll be done in less than 5 minutes. What happened, and one of the complications was that when the court case was settled and the statute was written for the original Rural Land Stewardship Program, the State Land Planning Agency decided that we needed to attach a rule to it, which complicated things, made things less clear, in fact. What happened was the rule, 9J5, I don't remember the numbers, but the rule that was attached to the Rural Land Stewardship Program is gone. It's been repealed. No longer exists, which is important. No longer a demonstration of need required. There was always some demonstration of need, but it was a simple test. It was made more complicated by the rule. No more demonstration of need, just like the sector plan. DCA oversight is basically eliminated. And there is a heightened role for the Department of Agriculture and Consumer Services. Again, it is a request. You do not have to involve any of the agencies, but DAX is now added to the list. I believe there wasn't much trust left in the State Land Planning Agency in sort of helping and facilitating these rural land stewardship areas along, and DAX was inserted as an option for you to help it along. Now, there's no DRI requirement, no development order review. I mean, you can pick your poison. No DRI requirement, but you still have to go through the comprehensive plan amendment process. There was always going to be some oversight. There was always going to be something, and that's it. But it's a local process. Again, affected parties can still appeal. And zoning. You will have to redo the zoning codes for this thing. And let me just tell you one last quick thing about the Rural Land Stewardship Area Program. While the sector plan encourages landowners to go ahead, it's just a different way of doing it, to go ahead and tell me really what you want to do on your property. Tell me what you think, what your vision is for your land holdings in the future, whether it's a new town, a new city, or whatever you call it. The Rural Land Stewardship Program adds a little twist to it. They actually have developed a system where you assign a value. I don't care whether it's a road, a canal, a citrus grove, a tomato field, whatever it is, or hardwood hammock or cypress swamp. You assign a value to that, the whole property. And out of that pool of values, you exchange those values for development rights, basically. There's a science to it. It was done because it was a court case. There needed to be some basis for deciding I want 5,000 units or I want 100,000 units and 10 million square feet of other things. So that's the little twist. I mean, in a sense, basing it on something like that, I'm not going to tell you it makes you any safer from any appeal, but there has been a court case on that has been resolved, and that, in fact, is, I think, an advantage of the Rural Land Stewardship Area Program if you want to feel a little better about what you're asking for. and how you sort of earn those credits on the land that you've been stewards of and you've managed for all these years to create a program. So, and I'll stop right there.
Hey, thank you, Mike.
Okay.
Jim, you want to talk to us about water supply planning?
I'm happy to do that. Good morning, everyone. When I was a young man many years ago, mid-70s, this wonderful gentleman came into my office. I was planning director of Orange County, and some of you may remember him or know him. His name is Henry Swanson. Wonderful guy. Henry was our agricultural extension agent, and Henry starts talking to me about water. And of course, I'm there thinking about Epcot, because Disney's just about to open that. What are the impacts of Epcot going to be? Because, believe it or not, Disney's probably the classic example of the mother of all sprawl. But Henry wants to talk about water, and his lead statement to me was, you know, Jim, there's good news and bad news about water. He says, the good news is that we're probably going to be able to treat it to the point we can drink it. That's the good news. The bad news is there's not going to be nearly enough of it. And so Henry was well ahead of his time in thinking about that in the mid-70s. And of course, some of you know he went on and put together what was called the Blue Law, and it had some tax benefits and so forth, although I don't think it's ever really been taken advantage of. But water is going to be a huge land use issue in the future. I've had the good fortune of working a lot with agribusiness, so I feel like I'm among friends. Everything from citrus to summer vegetables to timber to sugar. I've worked with the industry on land areas for all of those. So I have some sense of what goes on and what decisions are made and sort of the economic decisions that agribusiness makes. And I think, you know, your next crop, if you haven't already started, is water. I think Henry was absolutely right. We had a scare in the early part of this decade, about 2006, and the water management districts, and some of you may be very familiar with this, for Central Florida, for our 7 counties, took an area of it and said that's a water caution area, and if you don't, you as a government or you as a supplier of water don't convert to an alternative water supply that's not groundwater, that's not from the aquifer, if you will, by that date, we're not going to give you any more consumptive use permit. That's a huge, huge dictate. And everyone was running scared. And to some extent, I mean, we all know this economy has been just painful for everyone, but from a water standpoint, it probably gave us some time that we didn't have. But I'm here to tell you, and I think, again, a lot of you know this, I've been through 4 recessions, the worst one in the 70s, that we'll get through this, we'll put our heads down, we'll do what we have to do on a daily basis as individuals, we won't rely on the government to solve the problem, and we'll get through this. And, you know, will this be over in 2013 or 2015? Who the hell knows? I don't know. I don't think anybody knows. Certainly the talking heads and the pundits really don't know, but they're entertaining. But the bottom line is we'll get through it. And we'll have this problem. The water problem isn't going away. As a result of that, we had a group called My Region. It's myregion.org, that was a combination of all the local governments that came together in the business community in the 7 counties that we call Central Florida. And this group studied the area for about 3 years, came out with a recommendation called How Shall We Grow? How Shall We Grow? And in the How Shall We Grow recommendation, they said the first priority for Central Florida in terms of building our future was water. It was water. Not you'd think it'd be transportation. I mean, we had all kinds of transportation issues, but no, the big picture was water. And one of the things they understood is we didn't want to get in the same position that the Tampa Bay area got in, where we spent more money suing each other than we did solving the problem. And so consequently, they came to us, and at that point I'm representing the Urban Land Institute, and said, My Region and Urban Land Institute, get together and solve this problem, because at the end of the day, we don't value water. Water is so cheap and so plentiful, at least everyone thinks it is, that we're never going to have a problem where people go to the tap, turn on the tap, and no water comes out. Just not going to happen. I mean, just think about where we live and the geology and the geography of it. It's not going to happen. What is going to happen, though, is you're going to go to your mailbox and you're going to get your water bill and have a heart attack. Because at the end of the day, when you have to go to alternative water supplies, we're looking at 2 to 3 times, maybe 4 times if it's RO, reverse osmosis, what you're paying today. In Atlanta, they pay $65 on average every month for their water bill. In Orlando, we pay about $17. So when it goes from 17 to 65, which if we don't do anything about it at this point, it will, it's just a matter of time, then the bottom line is all of the people that we elected are going to lose their job. And so obviously they're very concerned about it, and that's why it was number one. So what we've done is we've done 2 things. We said we're going to develop a alternative water strategy or water supply strategy for Central Florida, and we've done 2 things. We did a white paper on water supply where basically we agreed on how we could go about creating the water supply that we need. The bottom line of that was we also discovered that no one jurisdiction in Central Florida, not Orlando, not Orange County, in terms of the big water suppliers, not one of them on their own financially can afford to solve their water supply problem. Think about that. Not one of them on their own, not OUC, not Orange County, not Lake Topeka or Toho Water Authority. So there has to be a collaboration. So the question is, are we going to get together and figure out how to do this collaboration, or are we going to be like Tampa Bay and go start suing each other? Well, we've already started to see what's going to happen if we don't collaborate, and there's probably 3 or 4 examples. I don't have time to give you them today. I'll just cite one of them, and that's the recent application for a consumptive use permit by Desiree Ranch, which has now been challenged by Orange County, and I think Orlando recently joined that challenge, and there are others. So here we go. So how are we going to collaborate? Well, what we've got up here that's in your document, and basically, I don't know if they're going to flip through this up here, is what we've come up with, what our recommendations are in terms of how we collaborate together to solve this water problem. We think ultimately it's going to start based on projects. We're not going to end up with a Tampa Bay Water Authority like Chuck Carden and his group have over in Tampa immediately. But we're going to build it with projects that we all come together and collaborate on. And at this point, we haven't had a very good track record of that. The Yankee Lake project in Seminole County fell apart in terms of people coming together on that. The project for saltwater treatment or reverse osmosis, the Coquina project up in Palm Coast fell apart, and the Volusia Water Authority fell apart. But they were all the first step, and they all were good efforts. And so what do we have to do to make sure in the future we meet those efforts? And basically what we've said is we're going to put together a memorandum of agreement among all the parties in the Congress of Regional Leaders, which is all the elected officials in that 7-county area, on how we get at water conservation, because that's the cheapest thing you can do is real water conservation. And even though everybody talks about, yes, we do this or do that, they really don't effectively deal with water conservation, especially the most important part of that, and that is how do we set water rates to really get people to conserve water. The second thing is we want to redefine the water management district priorities. We have 3 water management districts that serve our area. There's actually more water supply plans than that. I think there's a total of 5. Not one of them is based on a common set of data or a common set of modeling assumptions. We need one water management district to be looking at the water supply plan for all of Central Florida. We need another one to look at it from the standpoint of how we build the works that we need, the infrastructure we need for water supply, and we need another one to deal with regulation. And we're going to go after that pretty strong, both with the new head of the Department of Environmental Protection and the governor, and we're going to do that through our Congress of Regional Leaders. I'm running out of time, so I can't go through these. Obviously, they're all in there. You can take a look at them. I mean, you guys know how to read. You don't need me to read it to you. But we put some benchmarks in there because we're trying to create the crisis. We're trying to say, if we don't do what's in these benchmarks, then we're going to fail, and the failure is going to result in extraordinarily high water rates. Agriculture is part of the answer, and it's a big part of the answer. The ability to do the reservoirs, to intercept water from tide is probably the cheapest thing that we can do, and I think the public-private partnership opportunities between agribusiness and government here have some real opportunities in it, and I would encourage you all to look at it in context or in conjunction with your legal staff. Michael Minton was on our technical advisory panel. It's a huge help. These guys really understand water policy. They really understand how agribusiness and government can cooperate here. So look forward to answering any questions now or later, and would really encourage you to think about water as your next crop.
Great, thank you, Jim. I'd just like to cover a couple of bills with you guys that came out of the Florida legislature this year. There was some new legislation that can be helpful to agribusiness owners. One of those is House Bill 421, which expands an already existing agricultural exemption from obtaining water management district permits. Since the mid-1980s, Florida law has provided an exemption that said if you were engaged in agriculture, then you can alter the topography of your land without obtaining a water management district permit, as long as the primary purpose of that alteration isn't to impound water. In response to a 2009 lawsuit between a large agricultural company and the St. Johns River Water Management District, the legislature passed HB 421, which clarified that exemption. And what HB 421 provides is that you can impede or divert the flow of water or adversely affect wetlands as long as your activities are consistent with normal and customary practices in your area. And once again, that your sole and predominant purpose isn't to impede or divert the flow of water. This exemption is retroactive to July of 1984 and applies to lands that are qualified as agricultural for tax purposes. It does not apply to activities already authorized by existing water management district permits, however. One important aspect of this new law is that it grants the Department of Agriculture the ability to give a binding determination as to whether or not an agricultural operation satisfies the exemption. So now, if you have a disagreement between the ag operator and a water management district with respect to whether they fall under the exemption, there is an arbiter to go to, so you don't have to resolve it through litigation. And either the water management district or the property owner has the ability to request that binding determination from the Department of Agriculture. Another important thing that came out of this legislation that I think is going to be of interest to a lot of property owners is it addresses conversion from agricultural operations to development. And what it says is that if land is converted from agriculture to a non-ag use, no mitigation will be required to offset any adverse effects caused by the agricultural activities that occurred in the last 4 years prior to the conversion. Now, when I first read this, it seemed a little counterintuitive to me. Now, why is something that was done on the ag property in the last 4 years before conversion exempt, as opposed to something that took place 10 years before, 20 years before? It seemed to me that might be more worthy of the exemption. I talked with Mike Budell at the Department of Agriculture, and although the language isn't entirely clear, what was intended was that it be an ongoing activity, an activity that was ongoing during those last 4 years before conversion, so that it would be clear that it's not something that's a sham. In other words, you can't do something on the property in the last 6 months before conversion, ostensibly for agriculture, but really you're trying to blow out the wetlands so that you can then flip it to a developer. So what I guess DAX is going to put out rules on this, and what they're going to say is that the ag operation in question must have been ongoing in each of the 4 years prior to conversion. If that's the case, then you fall under the exemption, and the development would not be required to mitigate for those impacts. HB 421 also expands the definition of what kind of agricultural activities fall under that exemption, so that it includes cultivating, fallowing, leveling, as well as anything that would fall under a best management practice adopted by Department of Agriculture or the U.S. Department of Agriculture's Natural Resources Conservation Service. Again, provided that those things are not for the sole and predominant purpose of impeding or diverting flow of surface waters or impacting wetlands. Another important piece of legislation passed this year was House Bill 7103. This bill also expands some already existing protections for agriculture. In particular, in 2003, the legislature passed the Agricultural Lands and Practices Act, which prohibited counties from adopting duplicative ordinances or rules, which limited the activity of a farm operation if the activity was already regulated by a best management practice or by a state, regional, or federal regulatory program. The problem with that 2003 Act is some counties had already enacted ordinances which regulated agricultural lands, and it did not apply to those. Well, House Bill 7103 addresses this issue by providing that A, counties may not adopt new ordinances that are duplicative, and it also may not enforce existing ordinances that are duplicative. So if you fall under a best management practices, the county has a duplicative ordinance, either pre-existing or new, that's not enforceable. Another important change related to stormwater management. Counties may not charge assessments or fees for stormwater management on a bona fide farm operation on land classified as ag if the farm has a National Pollutant Discharge Elimination System permit, an ERP, works at a district permit, or if it falls under best management practices. And there are exemptions for counties that adopted a stormwater ordinance prior to March 1st of 2009, but in those cases, the county still must give credit to the ag operation if they fall under those BMPs or those other things that I listed. HB 7103 also created what's called the Agricultural Land Acknowledgement Act. This is kind of an interesting one. It's intended to address conflicts between an existing ag operation and a new residential development that comes in next door to it. And what it requires is that if a developer is developing let's say a residential project that's going to be next door to an ag operation, before they can get their development order, they must sign an affidavit that says they understand they are moving in next door to an existing ag operation, and that affidavit gets recorded in the public record. So what that does is anyone who is a future owner who buys a property in there, they are put on notice in the public records of the existing ag operation, which presumably would make it a little bit harder to sue for nuisance because you moved in next to a pig farm and claimed that you didn't know it was there. Lastly, HB 7207, this isn't strictly pertaining to ag, but a lot of my clients have had a lot of interest in this one this year. This is yet another permit extension. For the past 2 years, the legislature has adopted legislation that allowed for certain permits to be extended for 2 years. There's another piece of legislation that came out this year that does that, and it relates to building permits, local government issued development orders, FDEP permits, and certain water management district permits. And what's great about this legislation is if you already got an extension under Senate Bill 360 in 2009 or the bill that they passed last year, this one allows you to get an additional 2-year extension of that same permit. Also, if you have any permit that would have expired between January 1st, 2012 or January 1st, 2014, you can extend that for 2 years. The only limitation is that the total extensions can't be more than 4 years. And you have to get in a letter before the end of this year to the permitting authority letting them know that you are extending your permit, and you've got to meet the requirements set forth in the statute in that letter. So if you do that, you get another free extension. I've got a lot of clients that are taking advantage of that right now. If you've got permits that you may want to extend, even if you're not sure if you're going to do anything with them, it's very easy to do, and I would encourage you to take a look at those, and we'll be happy to help you with that. With that, I believe we're almost out of time. Do we have any quick questions for any of our panelists here? Yes, sir.
I wanted to ask a question on, we hear a lot about water being another crop or ag and that kind of thing. Are there efforts to define or economically justify what that value is? I mean, that seems to be one of the roadblocks, is trying to establish values
Right.
for that. And, you know, you hear it talked about a lot. I know there's pilot projects going on stormwater and cold water and these kinds of things for both the quality side and the quantity side. But the qualitative values of that, is there efforts underway to
Sure. Jim, would you like to address that?
Sure, and I'm sure you've got some examples. We're doing that now for several large agribusiness entities where with our hydrologists, we're going out and looking at what the surface runoff potential is, and then using the surface runoff potential and the amount of water supply that's going to be available as a basis for valuing the property. So something that's, say, from an agribusiness or timber standpoint might only be valued at $1,000 or $1,500 an acre, gets valued at $6,500 an acre, and then the area that the surface water runoff was coming from gets put in a conservation easement, and then the value of the conservation easement is usually about half of whatever the value is for the land that the water is being stored on. So in that case, if it was $6,000, then the conservation easement area value would be $3,000. And then the good news is under the conservation easement, you still get to timber the land that's left. So I think there's a real value added to agribusiness in that scenario.
Great, thank you, Jim. I'd like to thank my panelists. We've got a couple of excellent panelists here who are real experts in their field, so if you have questions, you might want to try and grab them afterward. Thank you, everybody.
Thank you, Lee.